Okay, so I don't know if y'all know it or not. It is Stress Awareness Month. And this whole month, I'm going to be sharing resources about stress and how you can de stress. Also, today, I want to talk about a major source of stress for a lot of people when they're getting started. Hey, Will on Instagram, thank you so much for joining. Right now, tonight, hey, Kanika, thank you so much for joining today. Thank y'all for being here. I want to talk today about losing thousands of dollars with your trademarks by not taking the steps you need to take to protect them, and also how you can de stress by taking some different steps when you go out to protect your trademarks. So I'm going live on Instagram. I'm also on YouTube today. So I'll be looking back and forth between the screens. But like I was saying, when I hopped on, it's Stress Awareness Month, and I want to share with you resources about de stressing. Hey, Tanya, thank you so much for joining. Appreciate you being here. It's Stress Awareness Month. I'm trying to de stress this month. I did some self care today. I went and got a pedicure. This was like the first pedicure I've gotten in a year, so I was very excited about it. If you are de stressing in some way this week, drop in the comments how you're de stressing. Maybe I'll take some of your ideas too. So, another thing you can do to de stress as entrepreneurs when you are protecting your brand, protecting your business. Hey, Brandon on LinkedIn, thank you so much for joining. Want to talk about de stressing by taking good steps with your trademark so you don't waste money, you don't waste time, and you don't waste energy. And there's really three things I want to talk about tonight, three mistakes that I see people making when they choose their trademarks. And I see some other lawyers watching today. So drop your recommendations in the comments too. Don't let me hog the conversation. So there are three mistakes people make with their trademarks that usually end up in them spending a ton of money and a ton of resources. The first is choosing the wrong trademark, so picking a bad name. The second is not talking to a lawyer soon enough. Hey, EMJ Writing, thank you for joining on Instagram. And the third mistake is thinking you need to save money on hiring a lawyer because they are too expensive. Hey, Edith, thank you so much for joining. So, as we are talking about ways to de stress by making better trademark choices, I want to tell you a little story about why I even started thinking about this topic. So, I've been applying for a bunch of trademarks lately because I'm rebranding my business. I'm going to be really excited to tell y'all about it later on this week, but I'm rebranding the business a bit. So I've been filing a ton of trademarks. And as I've been filing my own trademarks, I've been getting so much mail and so many emails from these third party companies that look like the trademark office but are not. And they send people invoices and they send people things that look like bills, and they're like, hey, if you send us $1,400 or $1,800 or $2,000 or whatever, your trademark will have a worldwide blah 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 registration. I've been a trademark lawyer 15 years, and I was looking at some of these things like, what are these people talking about? This makes absolutely no sense. And so I know if I'm looking at these things and I am like, what I'm not going to curse, but if I'm looking at it like WTF, and I know other people are. So I want to talk about this because I've had clients reach out to me in the past and they're like, hey, I'm going to go ahead and pay this. I just want to show it to you. And I have to stop them and say, wait a minute, you don't have to do this. And these are like thousands of dollars. So I don't want you to make these mistakes. So I want to talk tonight about those three things I mentioned that are mistakes people make when they are starting with their trademarks. The first is picking a bad trademark. And really, trademark lawyers throw this term around a lot, but we never really explain what it means. But one of the first mistakes you can make that can be really expensive is choosing a trademark that is too descriptive. So, trademarks exist on this spectrum of what we call descriptiveness or distinctiveness if it's not like a word or a phrase. But either way, the point is if your trademark is too close to the actual thing you're selling, if it describes what you're selling, if it's not distinct enough in the marketplace, then you've chosen a trademark that probably, if you hire a lawyer and spend thousands of dollars, you're going to lose in the trademark office. Because the trademark office and trademark law has really clear rules about trademarks and which things are always protectable, which things are never protectable, and which things are sometimes protectable. And it revolves around whether something is descriptive or not. So it's kind of like if I want to start an Apple store selling apples like the fruit, and I want to call my store the Apple Store for selling actual apples. That word is way too descriptive and arguably never represent a trademark for you. So, but you might go out and get business cards, a website. Y'all know how we do. We get the social media handles, we buy the domain name, we get the website together, we start doing all these things, and then we think about trademarks. But you could spend a ton of money getting a whole brand together, getting a website, doing all these things, and end up with a brand that not only is not protectable at all, but you've wasted money. And in some instances, you might pick something that might be protectable, but somebody else owns. So the first mistake you have to avoid is choosing a trademark that is too descriptive or not distinctive enough. Hey, Andrea, thank you so much for joining. I appreciate you being here. There are lots of IP lawyers here. I'm really excited to see y'all on LinkedIn and YouTube. So when you are picking a trademark, I know I keep saying this, but I have to hammer this point home. I see lots of lawyers in all the different spaces. Do not choose a name that is too descriptive, because if it is too descriptive, you could spend a ton of money, a ton of time, a ton of energy talking to LegalZoom or lawyers or whoever you're talking to, and you could end up losing money and not having a trademark that is worth anything. So that is the first mistake people make when they're picking trademarks. That can be a really expensive mistake, because your domain name is going to cost money, your website is going to cost money, your branding, your logos, all the different things you go out and rush to do before you find out whether or not the trademark is protectable. Thank you so much. What is that? What Seven Hearts? I appreciate that comment. Thank y'all. So there are some words I'm going to give you. We don't have a whole lot of time to get into all this, but if you have questions, drop those in the chat. Happy to answer as many questions as I can. So if you are getting started, I'm talking about like ground zero, and you're thinking about what you're going to name your business, what you're going to name your brand. There are these 5 different categories that trademark lawyers talk about a lot, that the law uses to describe whether or not you have anything that is protectable. So no matter what you go out and choose as your trademark, if you don't choose a word that exists on the right part of this trademark scale, you're not going to have anything worth protecting. Meaning, if somebody else wants to go out and call themselves the exact same thing, they can do that. Meaning, if somebody else has taken some more steps and has had some kind of descriptive word for longer, they are going to have senior rights to those words or to that phrase, to that logo, whatever, than you. And they could stop you from using those same words for your business. So I'm going to tell you these words. We can talk about them a little to the extent you want. But with trademarks, there are 3 categories of words and phrases that are going to be protectable so long as you meet the other legal requirements: arbitrary, fanciful, and suggestive. Basically, the further you get away from your word or phrase being descriptive, the more likely you are to have a trademark that's protectable. So arbitrary is when you make up a word. So things like Exxon, that was a made up word before it was a trademark. Kodak, which was a made up word before it was a trademark. Arbitrary things are words that basically were made up. They did not exist before you adopted them as a trademark. So they're awesome trademarks, but if you have a marketing person on your team, or if you're working with a marketer, marketers usually hate these kinds of trademarks because they don't tell you anything. So like Exxon doesn't tell me anything at all about a company that is an oil company or an oil and gas company. So marketers don't like it because you have to do too much to teach people what your trademark means. So this is something that usually causes a little there can be a little bit of a disconnect when you're getting started and you have a lawyer and you have a marketing person, because we are going to see things differently. But at any rate, choosing that arbitrary word or phrase is a guarantee that it is protectable. Now, that doesn't mean you are going to get it. There could be somebody else who, unbeknownst to you, has made up the same word or phrase, but you can start there with arbitrary words or phrases. The second 2, which are kind of like 2 sides of the same coin, are fanciful and suggestive. So, shoot, I said that backwards a little, but at any rate, fanciful words and phrases are the made up ones. Arbitrary and suggestive. Hey, Daryl, thank you. Arbitrary and suggestive trademarks are a little bit further down the spectrum, but also protectable. Because if it's arbitrary, that means you've taken a word that's in the dictionary and you've used it in a way that is arbitrary. So I said that a little bit backwards earlier, but stay with me. I have some stuff on my blog I'm happy to share with you if that was a little confusing. But with arbitrary words and phrases, hey Glover, BKF, hey Travelista, good to see y'all. Arbitrary words and phrases, when you take a word that already exists and you use it in a random arbitrary way. So earlier I was talking about an Apple store to sell apples. Like I would not be able to probably trademark the Apple store to sell apples because apple is a generic word that actually means the thing that I'm selling. But if I use the word Apple for my phone products or my laptop products, kind of like the Apple company currently does, then that's a pretty strong trademark because you've taken a word and you're using it in a completely different way. So that's arbitrary words and phrases that can be protectable as trademarks. Suggestive trademarks are things that are a little bit confusing to explain because what it basically means is you are suggesting a character or quality of your products or services. One of the best examples of this is actually a trademark that I think is one of the best is a trademark that actually is no longer a trademark, but it was heroin. So heroin used to be a trademark for a drug that was sold by a pharmaceutical company. Now it's a street drug and it's illegal, but they created this drug and called it heroin because when you took it, you felt like a hero. And so it suggested that if you took this drug, you would kind of like feel like a hero. And so suggestive words and phrases too. So arbitrary, fanciful, and suggestive are always going to be protectable as trademarks if you meet the other requirements, meaning nobody else is out there using it before you to sell the same products and services. You're the first in the market, and that kind of thing. Then there's this category that marketers love that lawyers don't love so much because they're really, really hard to protect as trademarks. And those are descriptive words and phrases. So, this is what I was saying earlier. You can make a huge mistake picking a trademark that is too descriptive because what the law says is descriptive words and phrases are not protectable as trademarks unless you take some additional steps and that word or phrase acquires something called secondary meaning, which means that when people see this descriptive word or phrase, they think about your business or um, they think about your product or service. So some examples of descriptive words and phrases that have acquired secondary meaning are like sharp for televisions, because sharp describes the television as having a very sharp image, and that is a descriptive word or phrase for a TV. But because Sharp has been in the market for a long time, they've done a ton of advertising, they've sold a ton of televisions and other products and services, that likely would be like a descriptive word or phrase that has become a trademark because it has that secondary meaning. So let me know if you have questions in the chat. Hey Maureen, thank you for joining on Instagram. I'm talking about mistakes people make when choosing trademarks and how you can not make these very expensive mistakes. So the first thing is avoid picking a bad trademark. Make sure you pick something that is a protectable trademark that is not too descriptive on that spectrum that we just talked about. The other thing that can make your trademark bad, and this is like really on a scale, right? So when you're choosing the word or phrase that you want to be a trademark or the logo or whatever, don't choose something that's too descriptive. But another mistake people make, especially when they don't hire a very astute trademark lawyer, somebody with tons of experience, like Tanya who's here, or Maureen who's here, or Andrea who's here, or some other people who are here, is picking the wrong class of products or services. So say you come up with something you think is dope and you are going to register this trademark with the USPTO. A lot of people try to do this on their own or do it with LegalZoom or whatever, and they don't get a good lawyer. You can pick the wrong category. So the trademark office calls these international classes, and there's a bunch of them. And you can pick the wrong class, the wrong category, and it can really mess up your future plans for your trademark. So if you register something in the wrong class and you don't have products or services in that class, you could really ruin the future value of your trademark and your ability to have anything protectable, because the trademark office is only going to give you a registration for your trademark for the way that you're actually using your trademark to sell products or services. So you can make a lot of wrong mistakes. And this is one reason why, and I know maybe I'm a little biased, but one reason why you need a good trademark lawyer. Even though it costs a little bit, you're probably going to spend a few $1,000s. You can make a ton of mistakes, and the trademark office is not very forgiving. I know there are some IP lawyers here watching right now. Y'all know the trademark office doesn't care if you misspelled a word. They don't care if you picked the wrong class. If you mess up, you have to start all the way over from the very beginning. And maybe that's happened to some people here. If you've tried to register your trademark by yourself and you've had some issues, drop in the chat what happened, and we can talk a little bit about how you might be able to pull yourself out of that and why I'm probably going to recommend a lawyer to help you figure that out and what that lawyer might tell you. So that's another mistake you can make, picking the wrong category, which the trademark office calls an international class. The another mistake you can make, and I have some notes here, but I can talk about whatever y'all want to talk about as it relates to this. Also, the trademark office is going to ask you to describe your products or your service, your goods or your services. So many people are selling, or a lot of people believe they're selling like a product. There's really only two categories the trademark office cares about: goods and services. But that could be any number of things that you're selling. But you have to describe what you're selling, or you have to describe the goods and services that you are going to sell, offer for sale, market, advertise, whatever in your business. And if you don't describe it the right way, you could harm your trademark's future ability to do what you want it to do. And this is really kind of like a negotiation between you and the trademark office, or your lawyer and the trademark office. You don't just like slap some things in your application and think, oh, this is, good enough. You can write your description too broad. You can write your description too narrow. And it is a little bit of a dance. Many lawyers that I know, trademark lawyers that I know, will start out pretty broad with the description of goods and services, and then you narrow it based on your negotiation with the trademark office. But a lot of folks, when they don't work with a professional who's done this for a while, they don't realize they need to do that, that you have to really kind of like negotiate. It's the same way like when you get a new job or whatever and you're negotiating your salary. You might have a number that you'll take, but you probably start out a little higher and then maybe you come down. Or if you're negotiating the price of a car or the price of a house, it's the same kind of thing. It's the same kind of dance. So that's another mistake that you should avoid when you are picking a trademark and when you are taking steps to protect your trademark. The other thing is not doing a search. And what do I mean by that? So what's common to do when people start their businesses is like doing a Google search, maybe doing a search on social media or whatever, which you should do those things. But there are some much more in-depth ways you can search to find out whether your trademark is owned by somebody else, whether somebody else is selling the same products or services or similar or related goods and services. Uh, Related goods and services in your specific field or industry. So if you don't do the right kind of trademark search, you could really, really create a bad situation for yourself when you go to register that trademark with the United States Patent and Trademark Office. So not doing a thorough trademark search can be very, very challenging. The final mistake, and then I see there's a question on LinkedIn from Daryl. I'm happy to engage with you on that question in a second, Daryl. And hey, Daryl, thank you for joining. But buying the domain and not registering the trademark. So if you are going to buy domains, get social media handles and all that, that's great. Those are steps you should take. But you should also, like, all this stuff should happen in tandem, be registering that trademark with the United States Patent and Trademark Office. So don't buy the domain and get the social media handles and think, oh, I'm good for right now. You want to do all of these things together so that you have like a full range of protection for your trademark. So you want the domain name, you want the social media handles, you want all of these things. And I'm sorry, y'all who are watching on Instagram. It looks like my connection went out a little bit, but we're back. So welcome back if you're still watching. So Daryl has a question on LinkedIn, and he says, "What if I had a trademark and it met the protectable test, but you haven't registered it?" And you've been using it for a long time and somebody else starts using the same thing. Now you want to trademark your original handle. Okay, so that's a very, very detailed question. And I can't give you legal advice, because Daryl, I know you're a lawyer. I can't give you legal advice because you're not my client. I'm a lawyer, but not your lawyer. Hey, Kanika, thank you for joining on LinkedIn. So this is a common issue. So the question Daryl asked on LinkedIn, for those of you who are watching on Instagram or on YouTube, is what if he had a trademark a long time ago, did not get it registered, now somebody else is using it, but not much, what can he do? This happens a lot because some people think, oh, I should wait a little while until I get the money together or until my business starts doing better or whatever to register a trademark, or I don't know how to find a lawyer, or a lawyer costs too much, or blah, 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 any number of reasons. What can you do when you had something, you didn't register it, now somebody else is using it? So this can be a challenge. Bought this new person has bought the domain name and has a similar handle. So without knowing a lot of details and not needing a lot of details, it could be the case that this new person, and I don't know if this, so the first question would be, has this new person registered the trademark with the United States Patent and Trademark Office? Have they taken steps to protect the trademark that way on a national scale with a federal trademark application? So I would have a lot of questions about what this new person has done, because it is true that a new person coming in selling the same goods or services or similar goods and services might have better rights to that trademark than you if they've registered the trademark or filed an application. If they haven't, then my recommendation would be to talk to a trademark lawyer about what you can do right now to protect the trademark in the way that you want to use it. Because the thing is, if you had it in 2013 and you were using it a little bit and then you stopped, then you may not have any trademark rights either at this point, because trademark rights are based on your actual actions and your activity, what you're actually doing. So if you just have a really good name for something and you aren't using it, you aren't selling anything with it, you don't have a website, you're not marketing a product or service, trademark law says, for the most part, that you don't have trademark rights in a thing either. Trademark rights are attached to use. Now, they're attached to use. There is something called an intent to use application you can file with the trademark office saying, I'm not using this trademark right now, but I plan to in the future. But you really need to talk to a trademark lawyer. For people who are in a similar situation, or you have a dope brand that needs a registered trademark, if you visit listentoblackwomen.com, you give me your email address, I'll send you a whole list of things about starting a business with conversations I've had in the past, and all kinds of things that will also include a list of Black women intellectual property lawyers who can help you navigate some of this stuff. So Stephanie on Instagram asks, did I miss the explanation between a trademark and a copyright? No, you didn't, because I didn't do one, but I'm happy to do that, Steph. Thank you for the question. So in terms of the difference between a trademark and a copyright, there's a little bit of overlap actually, but what a trademark protects is a word, a phrase, a sound, a designation, and designation could be interpreted really, really broadly to mean all kinds of things. But trademarks protect designations that you are using in the marketplace to distinguish yourself from other people in your market. When you're selling goods and services, you call yourself Apple for laptops because you want people to know that it's different from an Acer laptop, or a whatever other kind of laptop, Dell laptop, right? So the trademark protects the way that you are using a designation to sell products and services in the marketplace. It can be a logo, it can be words, it can be sounds. So if you remember like the Harlem Globetrotters theme song, that actually is a registered trademark because you always hear that song when the Harlem Globetrotters play basketball. It can also be motions. So like the way Lamborghini doors open, that is a registered trademark. If you do something really weird at your restaurant, designation can be interpreted really, really broadly. One of the most interesting registered trademarks I've ever seen is for goats on the roof of a restaurant. And there were actually more than one restaurants. There was more than one restaurant that had goats on the roof of a restaurant, and they had a whole trademark dispute about who owned the trademark to goats on the roof of a restaurant. So trademarks can be just about anything if you're using it to distinguish yourself in the marketplace as you sell your goods and services. A copyright, uh, a copyright protects your creative works, original works of authorship, which is a legal term, but like creative works that are fixed in a way where we can see them. So they can be pictures, it can be music, it can be movies, it can be all kinds of things. Why I said there's a little bit of an overlap, and thank you for this question, Steph, is because you can have something that is protectable as a trademark and a copyright. The same thing might have multiple types of intellectual property. So I mentioned the Harlem Globetrotters theme song, the Sweet Georgia Brown song. The sound of it is a registered trademark for the basketball team when they're playing basketball. The music is also protectable as a copyright because it's an original work fixed in a tangible medium such that we can perceive it for more than like the legal term is more than a transitory duration. Basically, that just means we can see it, we can hear it, we can touch it, we can feel it. So that's the difference between the two, though there can be overlap. And one of the things that happens a lot, and I've had this come up with some clients in the past, though I am not practicing law right now, where a person will get like a logo. They'll get a logo designed by a graphic designer, and then they want that logo to be their trademark. And they might get a registration for the trademark, like get a federal registration for the trademark, but they don't get the graphic designer to sign something saying you also own the copyright. So you want to make sure if you have logos, if you're hiring people to make music for a YouTube channel or whatever, that's going to be the music you always use to set yourself apart, that you consider whether or not your trademark might also be protectable as a copyright. They protect different things. So you can have one thing that's protectable lots of different ways. So I'm glad I answered your question, Steph. That's a really, really great question. Hey, everybody who's here, Valita, Courtney, Naturality on Instagram, thank you. So that is a mistake you can make too. You assume your content only has one intellectual property attached to it, and that is not always going to be the case at all. So Kanika asks on LinkedIn, can you talk about renewing trademarks? And yes, I can. So let me get there because this is a really, really, really good question about renewing your trademark. So say you take all the right steps, you pick a good trademark, you get the right class, you do the right search, or you get a lawyer to do the right search or whatever, you got all the things. What happens next? And this actually gets into my second point that I mentioned earlier. When you are thinking about protecting your trademark, another mistake you can make is not talking to a lawyer early enough. And the reason I say that, hey Kendra, thank you for joining on Instagram, is because so you make a mistake by not talking to a lawyer early enough, oftentimes because you don't know one or they're expensive or feel like you can do it on your own or whatever. I'm not saying that's what you did, Kanika, taking a long route to get to the answer to your question, but the lawyer can help you navigate all the crazy shit that happens when you file a trademark application. Because a lot of people think, okay, I filed a trademark application today, maybe I'll hear back next week, and me and the lawyer will go our separate ways. And that's not really how it works at all. You and that lawyer are going to be stuck together for a long time, maybe 8 months, 10 months, 12 months, because the trademark process is really, really Uh, it's deceivingly complicated, is what I would say. So you file the application, you or your lawyer, and the lawyer can help you figure out, like, have I checked all these boxes, blah blah blah. And once you file that application, you sit and wait, probably for about 3 months or so. And while you're waiting that three months, maybe 4 months, the United States Patent and Trademark Office is going to assign your application to a trademark examiner. And we had a person on here earlier, Andrea Evans, who's an IP lawyer who used to be a trademark examiner. She can explain this a whole lot better than me. I'm going to give you the very high level, but they give your application to one person. And then that one person is going to take about a month or so to look at your application and look for all those things we talked about earlier, whether you've met all these different requirements, whether when they do a search, do they find anything else out there. And once they look through it, if there are any issues, they're going to send you a letter. These are called office actions. And that office action, if you get one, is going to say, hey, here are the problems with your application. Now, maybe you're lucky and there are no problems with your application. You hire a dope lawyer who can help you navigate all this stuff. There are no problems at all. The trademark office says, yes, your application can go through. That's still going to take about 3 months or so. So now we're at, let's see, 3 months, then another month, that's 7 months at this point. And if there are no issues, it's probably going to take about 7 months. And what happens after that is the trademark office publishes your trademark application. And they say, hey, anybody out there in America who thinks this trademark shouldn't be registered, speak now, forever hold your peace. It's like going to a wedding. So they publish the trademark application and they say, hey, we haven't found any issues with this, but if you have an issue, please file something and let us know. So that process also takes about 3 months or so. And after that 3 months, then and only then does the trademark office register your trademark. And once they register your trademark, you aren't done even then. There's still some other things you have to do even at that point. So if the trademark office registers your trademark, from now until the day your trademark dies, meaning you stop using the trademark or you die and the trademark stops being used, or if your business owns the trademark, if your business is around 300 years, from now until never, from now until your trademark is no longer in existence, you have to renew your trademark at certain periods. And these periods are really kind of weird because the first one you have to renew between 5 or 6 years. And when you renew a trademark, a registered trademark, what you're saying is, hey, trademark office, I'm actually using this trademark to sell stuff. You have to declare, this is called a declaration. You have to declare, hey, I'm actually doing what I told y'all I was doing 5, 6 years ago. So you have about 5 or 6 years to do that. Then you have to do it again within like about 9 years or so. Then after that, you have to do it every 10 years. And basically, you are doing that to prove to the trademark office that you actually are using your trademark in the way you told them you were. And so it's not like tense thing, it's a form you have to fill out. But like with many things with the trademark office, it can be deceivingly complicated. So this is why, like, unless you feel really comfortable doing it on your own and all that, I think it's good to talk to a trademark lawyer. So Kanika says she's using a trademark lawyer. He filed it for you. But you want to make sure, this is another mistake people make. Make sure, and I'm not saying you made this mistake, Kanika, but make sure when you hire a lawyer, you find out from that lawyer, yo, what am I paying you to do? And what this $2,000 or $1,500 or whatever, what do I get for this amount of money? Because this mistake can be a big one. Hey, Stephen, thank you so much for joining. It is good to see you. So when you hire a trademark lawyer, maybe you're giving them $2,000 and all they're going to do is file the application for you. They're not going to go back and forth with the trademark office if there's a problem. They're not going to do anything else until you pay more than that original $2,000. Other lawyers are going to maybe charge you $2,000, and that includes getting you across the finish line, meaning getting you to the point where either the trademark office says yes, you get a trademark, or no, you don't. Because the trademark office can say no, you can spend all that money, they can say no, and you don't get your money back. So you want to find out from your trademark lawyer, what does this include? Are you getting me to the finish line? Are you just filing the application and not responding to any letters or office actions from the trademark office? What do I get? Because most trademark lawyers I know, if they're going to get you to the finish line, so Kanika asked a really good question about these renewals that I mentioned, these Section 8 declarations. They're not going to do that for you. They're not going to remind you every 10 years and 5 years and 8 or 9 years. They're not going to remind you you need to file this. And if you don't do it, you could lose your trademark. And the trademark office is a stickler for the patent and trademark office has rules and deadlines for a reason. And IP lawyers live and die by these rules and deadlines. So this is another good reason to work with a lawyer, because they can help you make sure that all those dates are going to be met. Every good IP lawyer I know has a really, really strong calendaring system so that they know all the deadlines for their different clients if the clients have retained them to do that. So you want to ask your lawyer, am I actually hiring you all the way through? Can you remind me about these declarations, these renewals I have to file? What are we doing here? How does all this work? So this is why I was saying it can look pretty expensive up front, right? When you're hiring a lawyer, a trademark lawyer, because that $2,000 or 1,500 or whatever you're paying, whatever you're paying the person, that can be a hard thing to swallow. But if you think about the fact that this is a person you're going to be with 10, 12 months, maybe getting your trademark registered, getting all the things you need to get done, $2,000 over the course of 10 months is like $200 a month or whatever. If that's what they charge you, I'm just using that as a round number. Hey, Ingrid, thank you very much for joining on YouTube. Thank you for your comment. That could be real. That's a long time, right? To spend with somebody, to be going back and forth, making sure you don't miss deadlines, making sure you respond to whatever the trademark office says. So ask a lot of questions up front. Because again, so to the question, I think it was Kanika who asked this question earlier. Say you get your application file and the trademark office says, hold on, wait a minute, there's a problem with your application. There's something wrong. Here's an office action. You have so many months to respond to, probably 6 months. You have to respond to this letter. Some lawyers, like that's not included in whatever you pay them to file your application. Some it is included. So you just want to make sure you have very clear expectations on what you get for the money. And so, in terms of money, the final thing I want to mention when we talk about mistakes you should avoid, so avoid picking the wrong trademark, avoid not working with a lawyer early enough. The third thing is don't make a mistake thinking your trademark lawyer is too expensive. And I'm saying this as a person who does not have a dog in this fight. I'm not telling y'all you need to like go throw money at some lawyer or this or that. All I'm saying is make sure that you understand what you are getting for the money. And many people look at $1,000, 2,000, 3,000, whatever, and they're like, "Yo, I don't want to pay that. That's too much. I can go to LegalZoom and get it for whatever $99, whatever LegalZoom charges. I don't know." But what you are getting is an actual lawyer. LegalZoom is not your lawyer. If you read the fine print, you look at all those little words people typically don't read. LegalZoom is not your lawyer. LegalZoom is not going to do a lot of this for you, and the price goes up exponentially when you do go with like a LegalZoom or somebody like that, and they have not anticipated having to go back and forth with the trademark office, and you end up spending even more than you would have hiring a lawyer. So let's talk about cost, because this is something that I think is a little bit hard for people to understand when it comes to trademark lawyers. Thank you, Jen. Thank you for joining on LinkedIn. And thank you for your comment about trademark lawyers. It can look pretty expensive on face value, but keep in mind that this is the way your clients, your customers, your target audience, how they're going to engage, how they're going to know that when they turn on uh, what if they turn on Minda Hart Secure the Seat Live, even though I don't see Minda's name, I'm thinking about Minda. Or if I see Career Rehab, I know that's Kanika Tolver's company, right? Or if I see a black podcast about black entrepreneurs, I don't see Stephen Hart's name, but I know he's got a podcast and he's got this trademark, this brand around this thing. Even if I don't see them, I know that this belongs to Stephen Hart or Kanika Tolver or Minda Harts. Or if I see from Cash to Crypto, I know that's Tanya Evans, whatever the case might be. So this is really important. This is valuable in your business, right? So in terms of prices, I want to talk money. If you have questions about money, have questions about any of this stuff, please let me know. I'm happy to answer your questions. Yes, Stephen, come holler at me. We can always talk about these things. All right, so how much does it cost, right? So there are a couple of questions you need to be thinking about if you hire a lawyer. I'm gonna give you some things you can ask them or you can find out from their firm before you even get on the phone with them. Is this an hourly fee or is it a fixed fee? So that's the first question. Like, is this a flat rate, a fixed fee, or is it hourly? Some people charge by the hour, some people charge a flat rate. It really just kind of depends. Many lawyers I know are moving to flat fees, at least for trademark applications, because even though it doesn't take very long, it requires knowledge and all of that. But that's the first thing you want to find out. Is this a flat fee or an hourly rate? Because, if it's an hourly rate, you want to know, is this something you're going to spend 10 hours, 5 hours, whatever? If it's a flat rate, you want to know, well, what does that actually include? Here are the things at minimum you should be wondering whether or not these rates include a clearance search. So we talked about doing a search. So find out whether your price includes a search. What kind of search? Does it include the application? Does it include the back and forth with the trademark office? So lawyers call this prosecution. Like, typically you think about prosecution in criminal cases, but you can have prosecution in trademark and patent cases too. Is that prosecution? So find out, what does all this include? Now, on average, so I'm getting these numbers from the Association of Intellectual Property, well, the American Intellectual Property Law Association. Sorry, my bra strap keeps coming down, but y'all just ignore that. So the AIPLA, the Association or American Intellectual Property Law Association, they do this every year. They survey lawyers and ask them, how much are y'all charging? On average, for fixed fees, clearance searches are $1,000 when they're fixed. Hourly fees on average are like $1,500. So if all you're going to hire a lawyer to do is a search, that search is probably going to be between $1,000 and $1,500 on average. Now that doesn't mean everybody's going to be $1,000 or $1,500. So I know some lawyers that are way more expensive than that, and they're absolutely worth it. I know some lawyers who are charging a lot less than that, and they're probably underpriced, frankly, which means, whatever that means. But a clearance search is probably going to cost you between $1,000, maybe $1,500, according to the AIPLA. The application itself is probably also going to cost you about $1,000. The numbers are very close. So if it's about $1,000 to $1,500 for the search, about $1,000 for the application. The third thing that typically happens is the prosecution. So if the trademark office says, hey, we have a problem, we need to go back and forth, prosecution is going to be between $1,000 and $1,500 also. So you should plan for about $2,000 to $3,000 on average in the United States. And that assumes there are no problems, there are no issues, you don't have to appeal, and all of that. And that just includes those first three things. The other stuff, so like your renewal applications that Kanika mentioned, your Section 8 and 15 declarations when you file an intent to use application, all those things. Those can be different prices. Those are usually, according to the AIPLA, I looked the numbers up, like about 500 or so dollars. So you should have that in mind when you are going to a lawyer, keeping in mind this lawyer is probably going to put in 10 months or so of work. And let me just say this final thing too about your intellectual property lawyers. You should treat lawyers the same way you treat doctors, right? So if I have tooth pain, I'm going to go to my dentist, right? I'm not going to go to my cardiologist and say, hey, dude, can you help me with my tooth? I'm not going to go to my cardiologist and say, ma'am, I have a problem with my foot, right? And my own opinion, other lawyers may agree or disagree, but my own opinion is find somebody who knows this stuff. Find somebody who does this stuff a lot. I'm not saying they have to only file trademark applications, but find somebody who does this stuff a lot. And here's why. Because there's always some little thing, there's always some nuance, there's always some difference. And you don't want to be in a position where you hire a lawyer and they don't know what they're doing, where like they have to go hire another lawyer to answer their questions. When I started my own firm, and actually I've done this too, so it's like no shame in it. But if I didn't know the answer to something and I didn't have anybody who I could ask for free, I would go pay another lawyer to answer my question. And lawyers have done that for me. I can't tell you how many times I've been a consultant for other lawyers who filed somebody's trademark application when they had no business doing it. They had a ton of questions and they ended up having to hire me to answer their question, which of course they just billed to the client. So you could end up spending more when you hire somebody who doesn't know what they're doing or who is not very familiar with trademarks. So when you're hiring somebody, ask them, like, is this something you do a lot? You can actually go to uspto.gov and search your lawyer's name and see how many trademark applications have they filed. So you want to pick somebody who can help you navigate all these crazy issues that might come up. All right, so we've been doing this about 48 minutes. My intention was to go about 30 minutes. I've gone over a little, but thank y'all for the questions. Make sure you get good trademark counsel when you're thinking about all these things. If you have fundamental basic questions where you really just want to know, like, how do I even get started with all of this? If you visit listentoblackwomen.com, I put a ton of resources together where you can get like some black women IP lawyers who can help you. There's some other videos in there. If you shoot me your email address, I'm happy to send those resources to you so that you can get started on a solid foundation with your trademarks and with your brand as you're thinking about these things. Thank y'all for joining me. I will be back next Wednesday. I think I want to continue talking about money next Wednesday and pricing, but I'm going to ask y'all what you think and then we can talk again next week. Thank y'all for joining me.